So the reading for 1.4 examines whether women write U.S. Supreme Court opinions with a different voice, different framing, meaning that they prioritize some form of language over another. The analysis of judicial opinions, judicial languages, is not new. Um, Law professors have been doing this for near time immemorial, as have judges. The analysis of a judicial opinion by looking at the text is something that has a long tradition, but its analysis in political science is very new. In fact, the way that this article actually goes about the analysis using a program called LIWIC to actually quantitatively demonstrate whether some opinions are different from others or use other language than others is a very new development within the field of judicial politics. Now, to give you a sort of background about this article, I think we should go into some depth to discuss how U.S. Supreme Court opinions are written. And to do that, we actually have to start after the Supreme Court has held oral arguments and when they meet in chambers. When the Supreme Court meets in chambers after oral arguments, they take an initial vote to determine what side of the case is actually going to win. And they vote in seniority order, meaning the Chief Justice of the Supreme Court votes first, and then the most senior person second, and so on down to the most junior, who under this court would be Justice Kavanaugh. After they vote in this order, they determine how many votes the winning side has, and the most senior member of that majority coalition assigns the opinion to a member of the majority. So let's say, for example, that Chief Justice John Roberts is in the majority coalition, which means he gets to decide who writes the opinion, or he gets to assign the opinion. He can choose anyone within the majority coalition to assign the opinion to. He can choose himself as well. Let's say it's a 9-0 court and he decides to assign the opinion to Justice Clarence Thomas. Justice Clarence Thomas will then draft a opinion and circulate it among the other justices in the majority. It is this process which makes me question, at least to some extent, the article that you read for this week with regard to different voices depending upon the author of the opinion. Once that opinion is circulated, so once Justice Thomas circulates the opinion, any member of the majority can request changes to be made, can request certain sections to be struck, may bargain over language even saying that I will join your judicial opinion, Justice Thomas, if you remove this section and choose not to focus on that part of the opinion. Then you will gain me as a vote for your majority opinion. This sort of bargaining significantly changes the tone, the text, and the precedent that ultimately comes out of the Supreme Court opinion. And we know that this bargaining takes place all the time. Individuals will bargain to increase the size of the majority coalition, to limit the effect of the precedent that will be articulated in the opinion. And this sort of back and forth is absolutely normal and absolutely to be expected. So this article attempts to compare the different judicial voices between men and women, and then goes on later in the article playing the different voices between Justice O'Connor and a number of liberal justices, Justice O'Connor being a conservative. And what the article finds is that there exists a large degree of variation dependent upon who's writing the opinion. Now, I think that effect is so robust that it's probably accurate. But we need to understand that there is a lot that goes into effect to shaping the language and text and discussion that exists within a majority opinion. In fact, the document, the majority opinion, is considered absolutely fluid until it's actually handed out by the court, until the decision is actually handed down. So from the point the opinion author writes their initial draft to the point that it is actually published by the court and released, the text of that document, indeed the coalition that makes up that document, can change. You could have a circumstance by which a 5-4 majority on the United States Supreme Court, let's say deciding a case in a conservative direction, switches to a 5-4 majority in a liberal direction because one of the judges refuses to join the majority opinion. So despite the fact that in committee they voted for it to be come down as a conservative opinion, this vote fluidity could change it so that it comes down as a liberal decision. So the majority opinion, as it was initially assigned, could actually become a dissenting opinion. And so this nature makes analysis of different frames and different language used within majority opinions to be somewhat difficult, because the majority opinion is not solely a product of its author. It is a cumulative product of the entirety of the majority coalition of the court. And so while there are definite robust findings in Dr. Crayville's study, we should perhaps take a step back and understand that unlike a dissenting opinion, which is almost always the product of an individual, a majority opinion, because it is binding precedent and because it is negotiated and fought over, is often the product of a collection of individuals coming together. And why authorship may be attributed to a specific person, the body of the document and the extent of the precedent actually is an entirely collaborative process.